Hello and welcome to the program. We'd like to specially welcome our viewers in Nigeria from the Salah holiday. Now, but while you were gone or you were away, we were busy ruminating over the implications of the National Electoral Offences Commission Bill 2021, which was passed by the Nigerian Senate on Tuesday, July 13th. This critical piece of legislation may have been drowned by the controversy surrounding the related Electoral Act Amendment Bill, which seeks to amend the Electoral Act 2010. However, on this program, we insist that both bills should and must be taken together for a more robust and holistic electoral system. That is why we are devoting quality time to the provisions of the bills, even as the lawmakers have embarked on yet another one of their many holidays or recess, as they call it. Well, on the program today, we shall focus special attention on the workability of the Electoral Offences Commission Bill with regard to the role reserved for the judiciary in its application. Sections 6, subsection 1, B and C, and section 11, subsection 1D of the bill mandates the Commission to investigate electoral offences created in any law in Nigeria and prosecute offenders. Section 33 in Part 5 of the bill deals with jurisdiction and special powers of courts to try electoral offences. Subsection 1 of that section grants jurisdiction to the Federal High Court, High Court of a state, or the High Court of the Federal Capital Territory, Abuja, to try electoral offenders and impose penalties provided for in the bill. Subsection 2B of the same section further enjoins the court to ensure that all matters brought before it by the Commission are given accelerated hearing. However, many are wondering whether the provisions of the bill as stated above can prove to be the silver bullet that will solve the well-known malaise in the Nigerian judicial system, namely delays, of course leading to denial of justice, frequent and long adjournments, mostly on technical grounds, political interferences, and most of all, corruption of judicial officers and officers of the court, resulting in the perversion of justice. Statistics indicate that hardly any one of the tens of thousands of electoral offences recorded during the 2011, 2015, and 2019 elections were and have been successfully prosecuted in Nigeria. In fact, the handling of 2 cases of alleged electoral fraud from the 2019 elections will suffice here. On Monday, July 12th, an Akwa Ibom High Court in Ikore-Ekpene granted the bail application of one Professor Peter Ogban. Ogban had been serving a 36-month jail term for illegal and unlawful allocation of votes during the 2019 senatorial election. Although the judge said his application did not meet exceptional circumstance, a euphemism for not meeting the conditions for grant of bail, he went on to grant the bail on the grounds that Ogban's appeal hearing may be delayed by the Court of Appeal. The second is that involving Professor Ignatius Udok, who was arraigned for declaration of false results in December 2020. Now, the Independent National Electoral Commission, INEC, claims the efforts to prosecute the case have been frustrated by the presiding judge, Justice Achibong. INEC says the judge has been indulging defense counsel in frivolous objections and adjournment for 7 long months. Now, with cases such as this, can the judiciary be relied on to make the proposed law effective and meaningful? Is the hope being placed on the Electoral Offences Commission bill to redress electoral malpractices and guarantee free and fair elections misplaced? Is Nigeria simply embarking on another wild goose chase? These are the issues we shall try to look into and resolve on the program today. So join us as my guest will be joining us very soon as we take another look at the Electoral Offences Commission bill. Stay with us. All right, thank you so much for staying with us. Let's get to meet our guest analysts. We have 3 of them. 2 will be joining us virtually via Zoom. One of them is right here in the studio with me. He's Barrister Tochukwu Ohazurike. Thank you so much, Barrister Ohazurike.
Always a pleasure to be here, sir.
And joining us virtually from Lagos is Barrister Chukwuma Ezeala. Barrister Ezeala, thank you so much for finding time to join us.
Thank you so much for having me.
Great. Right, we will be joined in a few minutes by Barrister Ojo Olasupo, who is also joining us from Lagos. Barrister Ohazurike, let me begin by asking you what your thinking, your thought process is about the Electoral Offences Commission bill in its entirety.
Thank you very much. I'd always expressed a personal opinion on the fact that there was ordinarily no need for creation of this Electoral Offences Commission. But people who are already wearing the shoe of the, who are in INEC, who are people I respect, the people with integrity in INEC, who I think have a better, are in a better position, in a vantage position to say it should be or it should not be, believe that creation of this commission is going to give staffers and of INEC more chance to do other things and concentrate on other areas and not to look at the issues of electoral offenders. So to that extent, I concede to what I will refer to as their superior argument that there is a need for this Electoral Offences Commission. However, when you look at that commission, you will now ask yourself, like when EFCC was created, you needed to move policemen to EFCC to do the investigation. So when you create this commission now, you are not going to get, there are no ordinarily trained civilian investigators in the commission. You will still need to bring policemen, the same Nigerian police, who could have ordinarily done this job of investigation while just in their stations in the police station. Now you will bring them to the commission, maybe just like EFCC has transited. After about 15, 20 years, you now transit to having their civilians in the commission who are trained to do the investigation. Now, when you still finish the investigation and you charge to court, it will also be the same Nigerian judiciary that you filed the charges before. Not like you are going to train new set of judges and justices who will try electoral offenses. It is still the same institutions of state as we have today that will still be there. So when I look at it, and the bad part that the proposal is that this commission will be headed by an executive secretary. So I'm already seeing a politician or a person who is partisan, particularly in favor of the ruling party, since the president, who is also a politician, who ascended to the throne of the presidency on the platform of a political party, is the one that will single-handedly make this appointment and will be told that he has a right to appoint people he can work with. So he can also appoint a politician who is going to be there as executive secretary and preside over this commission. The question now is, will this executive secretary very freely and willingly approve that persons who involve in electoral offenses in the ruling party, the party he has soft fought for, or the party, the man who appointed him is a member of and has soft spots for, will he easily and readily approve for trial for such persons? So when you look at the totality of this thing, well, like I said, I have considered to superior argument. So let me say, without being, how will I put it? Without being a prophet of doom, you know, let me say it's a step forward from where we are. Any step in the direct direction is a step forward. Yeah, it may be as slow as it should not be. It may not be as fast as it should be, but let's consider that it is a step in the right direction, and believe that when this commission law is, when it is assented to, the bill is assented to, that the commission will kick off. That is, if it is assented.
Right, because
I think it has to be.
Section 2 of that bill, which deals with members of the commission, actually provides for a chairman and a secretary, both of whom are supposed to be part-time members of the commission, you know. And the chairman is the chief executive and accounting officer of the commission.
Part-time, like I said, I made reference to the man that will appoint, the appointing authority.
And it also provides that the members of this commission shall not, it's very clear, shall not be registered members of any political
Now, you can see the tactics here. Shall not be registered members of any political party. Nigerians have not completely woken up from the event that happened about the nomination and rejection, eventual rejection of Lorito Noche. So if you now say shall not be members of shall not be registered members of a political party, you will see that it is not as clear as it was provided for in the Constitution. The Constitution said that the person shall not be a member of any political party, and again says the person shall not be partisan. So despite the fact that you're not a member of a political party, you can express partisan views. You can support a political party, support their programs, their manifesto, their candidates, without being a member of that political party. The Constitution says for INEC, you should not even hold partisan views. But here, when you just say not a member, it means that a Lorito Noche who suddenly said she had resigned from the party in 2019 would have been qualified to be the chairman of this. And when you, in such circumstances, you will see that the president is a politician. The president is a political party. He appoints somebody who now claims to have resigned from a political party, who is at the point of appointment not a registered member of a political party. What would he have achieved? So it's just 6 1/2 about playing and government being too smart, playing around with the intelligence of the and sensibilities of the Nigerian people.
Well, let's turn to Mr. Barrister Ezeala. Barrister Ezeala, apart from getting your general view of this bill that is now pending in the National Assembly, it's been passed by the Senate, but of course it's still pending in the House of Representatives, and it's only after that that we'll be talking of having a bill to pass on to the President for his assent. But we particular focus on the responsibilities that are assigned to the judiciary in this bill. What are your thoughts, first and foremost?
Anyway, my thoughts are that we are still going back to where we are coming from. We do not want to change the approach to the issues on board. Just like my colleague said, when you have such a commission who appoints, if you are creating an investigative position or an investigative authority, who is going to be responsible for this investigation? To what extent are you going to ensure that the authority is independent? My colleague mentioned about the position of the EFCC or any other that the president appoints. Some people said, okay, why don't you allow the judiciary to appoint? But it's also a problem. You can't really allow the judiciary to appoint because the judiciary will finally be the adjudicator. But why would you now not allow INEC to appoint executive secretary? And the problem are not personalities. Within the police force, we have a lot of good people. Within the security agencies, we have a lot of good people. It's a question of the influence of the politicians. I think that is what we have as a problem. And how do we navigate away from it? Now, we have seen what is happening in the judiciary now. The case in Akwa Ibom State. And it is very, very unfortunate. I don't know how to describe it. Far back in 2003, when there was a lot of electoral malpractice, some of us in the civil society, we were insisting that there should be a commission, and we were insisting that there should be the will to punish election defaulters or electoral malpractices, wherever they are coming from, whether from INEC officials, whether from ad hoc officials, whether from political parties. And the fight and the advocacy have been very consistent from 2003 till date. And imagine how many years, close to 20 years, or about 20 years. So I think we need to save this system because the system is corrupt. Now, Lagos states will be having their elections for the local government, which is the basic aspect, of politics, because that is the grassroots. People are not interested because they already know the results. They already know that that arm can never be thorough. So the advocacy continues, and I think that the media will assist the way AIT is doing now, trying to bring it on the front burner, bring election matters, electoral offenses to the front burner. Because if we don't deal with these issues will deal with us. If we don't allow the people to choose their representatives and their leaders, then we are only advocating for violence tomorrow. And we must avoid it. The media, everybody, all people of goodwill must be part of this process. They must be part of this advocacy for us to get it right. And it's very important. Thank you.
Barrister Ezeala, stay with us. For the past 22 years of Nigeria's return to democracy, we have always complained, whether it's the media, the civil society, security agencies, or even the politicians themselves, have always complained that we are unable to deal with electoral offenses, electoral malpractices at every level. And that was what led to the agitation for the creation of a commission such as this one, this bill is trying to address. But first, let's take a step backwards. How much have we done as institutions and as individuals to demonstrate our clear-cut willingness to deal with electoral malpractices and electoral offenses, either by INEC as an institution, the police or other security agencies, and the judiciary itself, which of course is the last leg of the entire process? Have we demonstrated enough courage, enough willingness to deal with these issues?
Certainly we have not demonstrated enough willingness to curb electoral offenses and the electoral malpractices. And like I said, since 2003, the campaign has been on. But unfortunately, the various people at the helm of affairs, it's just like what happened in 1983. You know, the ruling parties will always want to perpetuate election malpractices. And that is why it's very difficult to prosecute. You have the Attorney General appointed by the ruling party, and the Attorney General is the person to prosecute. The police is being controlled by the person that is perpetrating the election issues. But however, if we wait a minute and look at that breakthrough we have in Akwa Ibom State today, if we look at the role of INEC in supplying information leading to the conviction of someone who is said to have done electoral malpractice, we see that we are taking a step forward. But then, in another way again, we took some 2 steps back. Somebody was convicted. The next thing, the judge said, oh, we need to set him free for now because the Court of Appeal will delay. how can a lower court be indicting a superior court? How? How dare the judge make such what I may call a reckless, statement? You cannot indict a superior court. And even if you say it's because there will be vacation, even if you say it's because of vacation, we have vacation judges. So you cannot, in one breath, say he's convicted and he does not have a right, constitutional right to bail at that time. And at the same time, you say, okay, you go because of the position of the judiciary in Nigeria. It's an indictment on the entire judiciary. So I think it's an area that we will look at how would the judges, how would the judiciary as an entity. But remember that we will not continuously indict the judiciary because it was the judiciary that first convicted the person. And if he is a model, we will take to other parts of the states, rather to other parts of the country, in many other states, and look at what it was the role of the INEC in the conviction of this person. Who was in charge of INEC in that area? Did he do well? If he did well, then we need such people to be able to oversee some of the things we are doing. So I think while it is a step in the right direction, it was also a step backward or 2 steps backward. But then it's a learning process. So we recommend what has happened in INEC in Akwa Ibom State with a view to taking some of the anomalies, which the judiciary, I believe the CJ of Federal High Court is on it. And I believe that he will do the right thing. And I believe that during their various trainings, they will look at that area as an isolated and find out why the judge made such a mistake and how can it be corrected. But it will serve as the INEC people that worked hard to get it done. It will serve as a demoralizing force for them. Remember that many of them would have put their lives on the line, and what has happened? But I think we are moving. We still have credible people, both in INEC, both in the police, both in the judiciary, and every other place. And we need to identify those people and see that we move forward. Thank you.
All right, Mr. Ezala, stay with us. Let me turn to Mr. Awazurike here, and I'm going to ask you the same question, whether or not this bill actually provides a silver bullet for resolving electoral malpractices, malfeasance, and fraud in Nigeria, with particular reference to the role that the judiciary should and can play in this process. Given the background of where we are coming from, if we look at the statistics today, you will discover that there have been tens of thousands of electoral offenses committed in all the elections that were about 2011, 2015, 2019, and all the off-season elections here and there. A few of them have been taken to court. About only 2 have been talked about today. And these are the 2 in Akwa Ibom State, where one is still pending 7 months after the arraignment of the alleged offender, and the other one has been conclusively dealt with. But what we know as of today is that that same person has been granted bail. Somebody who is serving a 36-month jail term, granted bail from prison by High Court.
All right, thank you. I think I want to say clearly that these 2 convictions that you're making reference to are events.
Only one conviction.
No,
yes.
these two cases in court are parts of the reasons, or support my argument, my initial argument, that there was basically no need for this new bureaucracy that is being created. 1, the conviction of Professor Peter Ogban happened without this commission. The Nigeria police did not play any role in the investigation. INEC did their investigation on their own and went to court on their own and got this conviction. Now, the judge convicted in one, and the other judge is still, up to today, they are still grappling. The arguments in court for this, since that matter was assigned, is the right of INEC to appoint a lawyer. How can I say I'm contesting your right to appoint the lawyer of your choice? And the judge is listening to that argument, granting adjournments for that. So I ought to say, in fact, without mincing words, that I am surprised that INEC has left that matter in that court for this long without applying to the chief judge of Akwa Ibom State for a transfer of that case from that judge, because clearly the judge there has shown that he does not want to try that case, because you cannot be discussing such matters. A judge will tell you, sorry, counsel, you cannot dispute a man's right or the commission's right to choose his lawyers. People know that INEC does not have enough lawyers to do all their matters, and there are matters everywhere during elections. So INEC appoints external solicitors. So why will INEC appoint an external solicitor, having obtained the fiat of the Attorney General of Akwa Ibom State to even prosecute? They have obtained the fiat, and they are now appointed a lawyer. And the defense is arguing that INEC should not appoint an external lawyer, but must use somebody from within. It's not their business. So that is on one side. Now, let's look at the totality, use particularly what's happening in Akwa Ibom State to x-ray your question, because I think what is happening in Akwa Ibom State typically explains the situation where we are in, and also we show where we are coming from and where we may go if we are willing. The simple thing that has happened in Akwa Ibom is that a man was given a job to do as the resident electoral commissioner in Akwa Ibom State, and he agreed with himself that I will do my job to the best of my ability. And when people did the wrong thing, he did the right thing by allowing the law to run its full course. So if other people agree with themselves to do their jobs, we will not be seeing a situation where people will commit several offenses and will let them be. People kill people during elections, people snatch ballot boxes, but we'll just discuss it in the media and that ends it. But because a man has taken the step, so it's about convincing yourself first to do your job. That's when that will happen. Now, typically jumping into Akwa Ibom so that Nigerians will understand what has happened. But there were two matters filed by INEC. One has been ended by a conviction. Strangely, there was an application for bail pending appeal. Application for bail pending appeal, simply meaning grant me bail while I appeal this case, because I believe the appeal court will set me free. So it wouldn't be that I will spend time in prison wrongly. Why this came up, it was shocking. It did. The kind of thing that happened in Akwa Ibom was such that I may not be correct to say I understand it totally, because it looked like a movie that was directed by someone who wanted to hold everybody in suspense. Because counsel to Senator Chris Ekpenyong, who was the man against whom this Professor Peter Ogban played his tricks of election result alteration, his counsel in that matter, a person I respect so very much, Kanu Agabi SAN, former Attorney General of the Federation, turned out to be the man that filed the bail application for Professor Peter Ogban. And I'm like, but you are the man that was in the tribunal to prove that Peter Ogban altered the results. How come now you are his counsel?
That led to his conviction.
That led to his conviction. No, he proved in the tribunal that Peter Ogban altered the results. That led to Chris Ekpenyong being declared the winner.
Okay.
You now come to those facts must have formed part of the foundation with which INEC used to secure a conviction, and you are now filing a bail application for him. Now, that aside, the bail application contained issues of health challenges, but the thing was signed by a general practitioner, meaning that if it is something that could have been signed by a general practitioner, the Nigeria Correctional Service should have facilities good enough to treat ailments that a general practitioner thinks he should, not a consultant or a specialist in that area. But in giving his ruling, the judge now indicted the Court of Appeal and said the Court of Appeal will delay in this trial. He actually went into the future, saw into the future, and made a pronouncement speculatively about the future, that the Court of Appeal will delay in this man's trial, and Justice Pius Idiong, on that basis, no longer on the basis of the ill health that was filed, though nobody talked, the bail application did not allege that the Court of Appeal will delay. And the truth is this: as at the date the argument on this bail was being taken, the counsel to INEC pointed out to the judge, my lord, even now I'm hearing issues of delay by the Court of Appeal. That the man himself who has been convicted has not transmitted record 4 months after to the Court of Appeal. He has not even appealed the conviction, and yet we are here saying that the Court of Appeal will delay the appeal, when immediately they went and transmitted
the records and file their appeal in the Court of Appeal. The INEC lawyer professionally filed a notice, affidavit of service to show that he has been served with the notice of appeal and the records, meaning that the High Court was now functus officio. Functus officio meaning it can no longer look into that matter, that it is now having appeal having been formally entered in the Court of Appeal. No High Court should look at the matter again except the Court of Appeal. And the judge was visibly angry, asking the lawyer, why are you doing this? It is the prosecutor, it is the defendant that should be telling me that they have, not you. It's not the judge's business. You have been given an information that is a fact at the point you are giving, that you are no longer supposed to open this file. Matter is in the Court of Appeal. He opened the file, went ahead, and granted bail pending appeal. Now, the issues are, there are a legion of issues here. One, the people who have done a good job, who this conviction would have been an encouragement and an example for other states and other people to look at and say, we will do our jobs. We will now see that abracadabra has happened, and the man is walking free. His appeal was filed on the 12th of July, just a few days ago. That was the date the counsel to INEC filed his affidavit of service to show that there is an appeal now. So the judge, don't look at this part. But the judge went ahead and granted, and in granting the appeal, the law is clear about bail pending appeal and the conditions to obtain bail pending appeal. You must give an unusual reason. You must give exceptional circumstances why you should not be in prison, because having been found guilty and convicted, it means the law is you should be in prison. But for you not to be in prison, the law says you must prove certain exceptional circumstances. But because the man did not prove any exceptional circumstances, he only brought a medical report from a general practitioner medical doctor. The judge agreed. Professor Ogban, you did not prove any exceptional circumstances that should warrant the court to grant your appeal. However, I will grant your bail application. Do you understand that? That the foundation on which you should have granted it, he says to Professor Ogban, you did not give me that foundation. However, as the Father Christmas I am, I, Justice Pius Idiong, I'm the Father Christmas, I will grant it to you. I like you. You're a professor. I like you. That was exactly what should have played in his mind. And he granted this bail application. And the man today is walking free, making it look like maybe the man even knew he was going to be granted bail and the terms of his bail, because the moment the court rose, he fulfilled his bail condition, off he went, thereby stopping any quick moves by the prosecution, INEC now, going to the Court of Appeal to overrule that position. The man has been let go, and he's walking free. So when you look at these things, you ask yourself, should a judge fight the case of a man who has been convicted? So when we now say we have created a commission, and we have not created a commission of judges and justices that will also do the right thing, if we think this is the right thing, then there are a lot of issues here. There are good judges. So the man who convicted him, Justice Augustine Adoko, a good judge. In 3 months, that matter came to him in December. By March, he had given judgment. Justice Achibong of the other case, assigned the same time, is still discussing whether INEC has a right to. So when you see good judges, you applaud them, and you will see them. Everybody sees them. When you see the other ones, I didn't call them bad ones, but when you see the other ones who are not just so good, it's obvious too.
All right. Well, let's take a short break, and when we return, we will be joined by Barrister Olasupo Ojo, who will be joining us virtually from Lagos. And of course, then we will now be using this as a peg, what we just talked about with the cases in Akwa Ibom, as a peg to look at Section 33 of the Electoral Offences Commission Bill, which deals with jurisdiction and special courts, special powers of the courts to deal with electoral offenses and offenders. Stay with us. Thank you so much for staying with us. Let's welcome Barrister Olasupo Ojo, who is joining us now via Zoom from Lagos. Barrister Ojo, thank you for finding time to join us on the program. Well, let's go straight to the provisions of Section 33 of the bill, the proposed law, which deals with jurisdiction and special powers of courts. That this bill actually gives the powers to try electoral offenses to Federal High Court, High Court of a state, or the High Court of the Federal Capital Territory, Abuja. Now, some people think that perhaps there should be special courts created to try electoral offenses, just as the way we have electoral tribunals trying cases of electoral disputes. And that when you give high courts of the federal high courts, state high courts, and high court of the federal capital territory the powers to try electoral offenses, one, we might have situation as we have in Akwa Ibom today, where cases will be delayed for as long as possible. They will drag for as long as possible. We might also have cases where the courts in those areas may be susceptible to a lot of political influence, depending on which party is in charge in any of those states. What are your thoughts?
Yes, for a long time, we have been advocating for the establishment of electoral offenses, special electoral offenses court. We never advocated that it should be merged with the conventional court. So those who propose that bill, they still have some work to do. It's supposed to be a special court with a targeted jurisdiction, so that the judges that will preside in those courts will have to be specially trained for the purpose of exercising the jurisdiction and the powers that will be conferred on such courts by law. It is an unusual offense. It is like a treasonable offense when people gang up together or conspire or engage in any act that is likely to deprive the people of their choice in election. It is a treasonable offense, it's a capital offense, and it's supposed to be given to a special court with special powers and jurisdiction and with special personnel. To merge it with the jurisdiction of the High Court, Federal High Court, is not going to work. We have seen it happen in the Professor Oban's matter. You can see the way the judge actually entered the arena and went beyond his brief as a judge. He entered the arena and was engaging, even though when reminded of what the position of the law is. At the point I learned that he also opined that after all the PDP candidate has won. Why are they opposing the application for bail? It's because he is from that environment. So he can be influenced, and so it is better to have a court, even judges that will be specially trained for that purpose. Look at TFCC, for instance. Even though we have our reservations, there are some judges who are specially trained for prosecuting economic offenses. The same thing, some judges must be specially trained, and for the purpose of election comes once in 4 years. So those judges, their number should be determined, and they should be positioned somewhere. And if it is said that, you want the jurisdiction of the High Court to be preserved because it is once in 4 years that the elections take place, that electoral offenses are committed, we advise that some judges should be selected and trained for that purpose. If possible, they can even look at retired judges or even choose special tribunals. Tribunals need not be judges only. There are lawyers who are qualified, who can be trained for electoral offenses, prosecution, and trial, and they will still perform well. So there's need to look into that bill once again to be able to avoid the experience we are talking about. Thank you.
So what happens, Mr. Joe, what happens during the off-election season when you have special courts and special judges or special tribunals? What will they be doing when there are no elections and there are no election offenses to be tried?
Yeah, that's the point I was making. During the off-election, election takes place only once in 4 years. In those 3 years, what will they be doing? Of course, that's why I suggested we don't have to use conventional judges. There are young, intelligent materials, persons who are learned in law, who can be selected and trained for the purpose of this electoral offences tribunal. They can be selected and trained to come and work. They will work during when the court is in session. When the court is off session, they go back to their other job. I think that's the thing to do. It should not be a permanent court because it will be a waste of resources, and it won't work that way. So it's better to amend that bill so that you can select judges. You can ask people to apply to become judges of those tribunals. They will be interviewed, and then the best among them can be constituted to that court, and then they will they will be well trained for the work, and they deliver the work and go back to their job thereafter, so that there will be no waste of resources.
All right, Mr. Ojo, stay with us. Let's turn to Barrister Ezeala, if he's still there with us. Barrister Ezeala, these two cases in point in Akwa Ibom State seem to give some pointer to whether or not we might be able to restore some dignity, some discipline to the judicial system in Nigeria, to the administration of justice system in Nigeria, where a case has been pending for 7 long months and is only be dealing with preliminary issues, technicalities and all of that, and in the second case where a high court is said to have granted bail to a convict who is already serving his term.
I don't know. I couldn't hear you well. I heard my colleague, Mr. Ojo, well, but I didn't hear you well. I don't understand. But then, if it's the same line of question that you asked him, that you also getting to me, my view there would be, I align myself with what he said, that there is a need to have independent persons to do this, recruited for this purpose. However, there are also disadvantages of having independent people who are just ordinarily practicing, because they would not have trained fully, they would not have had experience in this. But the judiciary can have, because there are areas they say that hearings. So if the CJ would say designate some judges, just the way they designate election judges, electoral election judges, tribunals. So you can have such
Mr. Ezeala, I'm afraid we are unable.
Not overlook.
Yes, there's a lot of interference in your microphone there.
I can't hear you.
There's a lot of interference with your microphone there. And so we are unable to hear clearly what you are saying here in the studio. If that can be quickly corrected, then we can return to you. But Mr. Tochukwu, let me pose that same question to you that I posed to Mr. Ojo.
See, institutions of state must do their jobs. If you are a judge, do your job. If you are an INEC, do your job. If you are in the police, do your job. If you are in the Electoral Offences Commission, do your job. If you are in the NJC, do your job. Because I believe that Justice Pius Idiong, based on what has happened in this particular case of Professor Peter Ogban, is a candidate of the NJC. NJC should ordinarily look at that matter and find out whether a judge should be this determined to set a convict free, even giving reasons that are not adduced by the convict, to the extent of saying, why are you opposing bail? After all, the PDP that complained that the thing was done against them eventually won the election. Now, do you understand that kind of thing? So it was actually making case for them, and to the extent of indicting the Court of Appeal and all that. Institutions of state must be seen doing their jobs, so that it's not about creating a commission and leaving it there. Because when you create a commission and leave it there, and you give wide jurisdiction, again, you look at the way judges are created, are appointed in the various state jurisdictions. Now you have given jurisdiction to federal high courts and state high courts.
And high court of the federal capital
and high court of the FCT. Now let's leave the federal high court and the high court of the FCT.
and look at how the governors in each of their states regulate and manipulate and play a major role in the appointment of the judges in their states, you will see that we have actually gone back, taking 1 step forward and 7 steps backward. Just like the state independent electoral commissions. I don't think I just tell people, maybe sometimes in the civil society, somebody says, I want to run for local government. I say, you want to waste your money. Except you are a Nigerian who has been called by your governor and anointed to go and contest. Don't bother, because you will win the votes, but the other person anointed by the governor will win the seat. So you end up wasting your money. You will not go back to the same judiciary, and you will not get anything, because the governor will also play a role in ensuring that the judiciary does not give you justice. I've been part of that type of thing in Anambra State once. We got the tribunal to grant victory, and the governor directed that the man will not be sworn in as a state local government chairman. That he will not be sworn in. Because if he's not sworn in, yes, the court has declared him winner. He won at the tribunal. He won at the appeal in a Ihiala local government area. Let me be specific. Ihiala local government area. Ezego Dinilo. He won. But the governor said, I will not swear you in. And he was never sworn in. And with his immunity, he couldn't have done anything to the governor. So when we have laws that leave a lot of discretion to individuals, that's what we will face. Because when a governor does not do anything that the court has said he should go and do, I begin to wonder, can you now go and proceed against him in contempt years after he has left office? So you see that those things don't work. Institutions of state must hold Nigeria first. The same way governors, that's the fear of state policing, is because people have seen what governors have perfected in doing with the state independent electoral commissions. So when you give them state police, people are looking at it from that prism. Now, issues of the state judiciaries, you can see the battle Jusun went through to get autonomy for the state judiciary. If this judiciary arm of government is at least independent of the state governors, so to some extent, you will see what is happening. Look at what is happening in the houses of assembly of the states and the way the governors regulate and manipulate and control them, because they are not independent. What is happening in the crisis in Imo State today is because people say, they've not got to what they are supposed to get because the governor is holding it. So when you look at the totality of these institutions and you see that we have a National Assembly that continues to make laws and set up those laws for failure, just like how can you come and now say NCC should approve what INEC is doing when the constitution is clear? And I begin to wonder, come on, are these guys really Nigerians, or did we import people from somewhere else to come and manipulate Nigeria? Because if you are a Nigerian, if you are a lawmaker claiming to have the mandate of people, you will know that the constitution is the ground norm, is the ultimate law of the country. And the constitution says no other authority, any executive or INEC, should not be subject to any other authority, including Mr. President. And now the National Assembly sits in an act, not by amending that constitution, but in an act of the parliament, now saying that NCC should approve before INEC will take a step. And that approval will be further approved by the National Assembly. See, in fact, if we don't tell ourselves the truth in this country, these things are so painful when they happen.
All right, Mr. Barrister Ojo, let's look at another aspect of this. Now, we understand Ojo is no longer there, but is Barrister Ezeala still with us? We can talk to Barrister Ezeala right now. So Ezeala, as we round off our discussion, now this bill, if eventually passed and assented to by Mr. President, will become a law. Now, in Nigeria, there is, of course, 2 levels of electoral conduct. That is, the elections that are conducted by INEC and the ones that are conducted by the state electoral, independent electoral commissions. Now, with this law, with this, if it becomes law, with these provisions of this bill apply to local government elections, which are conducted by state independent electoral commissions, or will the states then proceed to set up their own electoral offences commissions?
You know, we have a paradox in Nigeria. Things don't work the way it should work. Now, I imagine ordinarily there will be no problem because the legislation on crime is under the concurrent list. to legislate on crime, whether election offenses is on the concurrent list. So ordinarily, it should supersede. But I imagine some state governors will go in now and start saying we need to have our own law. But however, whether they have it or not, nothing stops the federal law from operating. Yes, the state law is the one that governs elections to the local government. But once an issue of crime comes in, my view, subject to whatever the Supreme Court may think later, because it gets up to the Supreme Court, is that whatever law we have on election crimes, even if a state wants to have something, it should align with that law. But I think it's very important we have one central law for election malpractices. Otherwise, many will water their own. Many of the states may decide to give the prosecution powers to the Attorney General and may decide to even give appointing powers of the Commission to also the various state governments. But we must be very careful because we are dangerously treading into a very dangerous system in Nigeria. Thank you.
All right, thank you so much, Barrister Chukwuma Ezeala. Thank you for your time on the program today. And of course, right here in the studio, we had Barrister Tochukwu Azurike and Barrister Ojo Olasupo also joined us virtually from Lagos. Unfortunately, we lost the link to him somewhere along the line, but thank you for your invaluable contributions, gentlemen. And that's our program for today on People, Politics, and Power. I am Imoni Amariri. Join us again when we bring you a fresh edition of the program.